So do I believe that the Restore, and that's a giant, congressional acronym, Patent Rights Act and the Prevail Act will rebalance the scales of patent infringement?
I don't know. Yeah, newsflash, Matt, the trademark attorney, does not know.
Well, and I'll of course give lots of disclaimers. Here at Bold, we have, I would say, a specialty within patents, and like a lot of things, as soon as you kind of get into niches, there's even more, right?
Yeah.
And so we focus, obviously, patent law. We actually don't do litigation at the moment, right? We do what's called pre-litigation infringement analysis. When it comes to actually filing cases in federal court, we use our partners because they're in court. They're used to those proceedings, litigating and settling. So
it's incredible for those, for those listening at home. It is very rare to be either a patent or trademark practitioner and be both on the registration, transactional side and the litigation side, especially if you're doing federal court litigation.
Yeah.
At our firm, occasionally we'd send cease and desist letters and do TTAB litigation, which is Trademark Trial and Appeal Board litigation, but we leave the litigation to the litigators.
Yeah, absolutely.
It's too much to balance both of those.
Yeah. That said, it is important that us patent prosecutors are still aware of the law.
Yep.
Because it's true. Even though, let's say, a patent gets granted a year ago, patent laws change. Federal Circuit, Supreme Court cases get handed down that do eventually change the law in terms of the scope of rights that you have. The most recent one, of course, was the change to abstract idea and the concept of whether a software or computer implemented invention is eligible. A lot of those did, in the years following that Supreme Court case of Alice versus CLS Bank, were struck down as invalid. It's a giant, easy example, and it can happen. Now, in this case, this is sort of on the front end of the law creation. This sort of came from a case, eBay versus Microsoft, and that case was talking about a rebuttable presumption of here we go, some legalese coming in. Rebuttable presumption.
Rebuttable presumption. So who's got the onus here? Yeah. All right, here we go.
I'm gonna try to get this right. Rebuttable presumption of a what's the wording? It's a injunction. Okay, of a permanent injunction. When a court, right, when a judge says final ruling, there is infringement. Should there be a rebuttable presumption of a permanent injunction? So let's unpack that. That's the question.
I vote yes.
Well, and so that case I talked about, eBay back in 2006, put a question mark on that because it said, you know what? No, we're not going to use this old four-prong test. We're not always going to assume that. And so the problem there is that even though as a plaintiff, right, let's say the little guy wins, right, gets the win against the big guy, that you infringe my patent. No longer can they expect to have their infringer stop. For goodness sake. So what this act would do is it would restore, and as a plaintiff, is a patent owner friendly bill. So of course I'm going to be in favor of that, at least the way I read through it. But what it will do is it'll give that via the law, right? So it'll take it out of the hands of the judge and say, look, the law actually says as soon as there is a definitive judgment on infringement, the infringer must stop, must cease, absolutely stop any, making, using, selling, or importing of that claimed subject matter.
Okay.
And now it's on the defense to come up with some wild, crazy, convincing argument otherwise. So that's really what it is. And I do think that we'll work toward rebalancing the scales toward, the patent owner. That's a long-winded way of saying that. Quick note on the Prevail Act. I did dig in a little bit. It is over my head, frankly, having to do with what's called IPR, inter partes review, post-judgment at the Federal Circuit. What this is aiming at doing is basically cleaning it up. As it is now, defendants can face two separate attacks. Federal court and IPR. Honestly, and you went to law school, right? The whole concept of, the plaintiffs shouldn't get two bites at the apple, right? In general, you should try to, what's it, stare decisis? Nah, I'm not gonna try to quote the Latin here, but you should all be handled in one case. So it's efficient, all things handled in once, and you have a final decision.
And no double jeopardy.
There it is, double jeopardy. No ability to come back and just allege the same, underlying cause of action again.
Yeah.
So that's kind of what the Prevail Act does. There is sort of this gap or loophole, if you will, where they can get hit by the PTAB and federal court on basically the same subject matter.
Sure.
So I appreciate that question coming in.